All right. So we are going to record this. Hopefully it works out. And then we will let you know how that's available. If anyone has issues with us recording the question and answer time at the end, please do mention that in the chat, and we could always stop the recording before we do that part. So if this is your first time on Zoom, a special welcome to you. One of our lawyers, Alex Boland, one of our lawyers from the Kelowna office, he's going to be watching the chat feature, and he can help you with he'll try to help you with any technical issues. Right now, everyone's automatically muted since we're going to have a number of people here. We're up to about 50 at the moment. And so because we have that many, we are going to wait and address questions at the end, rather than having questions throughout the presentation. So you can access the chat feature as we're talking. Feel free to leave questions there as you think of them. To post questions that you'd like addressed at the end. We also might have some professionals in our midst who may have resource links that you'd like to provide and post. You can do that in the chat as well. As I mentioned before, don't worry if you need to get up and deal with kids or dogs or have interruptions. It's perfectly fine. And also, if you do want to turn your camera on so we can see you, we're happy to see who you are, or you can leave it off. So Shelley and I both realize that this is a difficult time for all parents, but it's especially difficult for parents who are separated. Some are either navigating living in the same house while separated, and others are co-parenting from two homes. So we want to say up front that in this forum today, neither of us can provide specific legal advice. I am a lawyer and a mediator by trade, and so I will be giving legal information during our talk, and including what the courts are saying thus far during this time of COVID-19. But if you do want specific legal advice about your particular situation, then we would need to talk about that outside of this arena. Shelley, my co-host, she's a social worker and a registered clinical counselor who works as a divorce coach and a parenting coach as part of her work with families. And so you'll be hearing from both of us. Shelley and I are both trained as collaborative professionals. And if you haven't heard of that, collaborative divorce is essentially a separation process that is completely out of court, and it's meant to assist separating couples in a more holistic, non-adversarial manner. So that's how we know each other from our work together in Collaborative Divorce Vancouver. So we trust that hearing from the two of us, having two different perspectives as people that are working with separating couples, one as a mediator and lawyer and the other as a divorce coach, that will deepen your knowledge and help you in some practical ways during this unprecedented time. So just to explain the format, Shelley and I are going to take turns speaking on a few general topics. First, Shelley is going to consider some guidelines that all parents should think about or understand during this time of pandemic. Then I'm going to review some basic legal concepts relevant to parents. And then Shelley will talk about some considerations for parents who are making an agreement during this chaotic time. Topics to consider. And then I'm going to look at what the courts are saying so far about parenting during COVID-19. So finally, we plan to leave a good amount of time at the end for questions. We have received a whole list of questions ahead of time, thanks to those that sent those. But you can also add questions to the chat. And then if we also have time, we can use the raise hand feature on Zoom, and you could ask some questions live at the end. So thanks for being here with us today, and I'm going to hand it over to Shelley for her first section.
Okay. Hi, everybody. Thank you for the introduction, Rebecca. I'm going to start by just talking to you a little bit about sort of fear and self-care and what it means to be living in this new normal. As parents and going through a separation or a divorce during this difficult time, one of the most important things is that you take care of yourself. So I'm going to talk to you a little bit about the emotional and physical changes that people experience when they're going through a difficult time. I want you to keep in mind both understanding this about yourself, but also keeping in mind that for others as well, being your ex or whether that be other family members or friends, as you're relating to people, understand that this might be going on for you and the people around you. So some of the emotional experiences that people have when they're going through a crisis, people can be more angry, they get more upset, they're triggered easily. They may say things that may come out in ways that just don't make any sense. They're really reacting from their emotional side, their emotional brain, the right brain, rather than their logical left brain. People are becoming more anxious, feel helpless. We don't know sort of what the new normal is like. All the different changes in the media coming up, you just can't quite tell. Some people go into denial. They may not want to talk about what's going on. They just don't want to hear about it. So be aware, of that. That's really normal. People can become easily startled. They'll react. They'll feel like just loud sounds or anything may affect them in a different way. Another thing that could come up for many is coming up with sort of flashbacks and feelings about memories of things that may have happened that are unrelated to this, may feel like they come to the surface right now. Things that we think that we may have resolved are not entirely resolved. So when it comes to dealing with issues like co-parenting, like making decisions about finances, it can come with so much more energy because it could be related to things that you may have felt that are in the past and have come up. So people are more irritable. We are all a lot more overprotective of ourselves and our children based on what's going on today. So some of the physical changes you may feel. People feel a change in appetite. Some people may get some chest pains and dizzy spells. There's headaches, heart palpitations. And people also find that their sleep is not quite, they can't sleep enough. Nightmares come, watching out for the news. So these are some of the physical and the emotional changes that people go through right now. And as we're sort of navigating this new land, part of it is to really kind of acknowledge these things that may come up for you, and certain things you can do to deal with that is to sort of work on relaxation exercises. There's some wonderful apps available. There's an app called Calm, CALM, that you can access, and that can help sort of work through some of the fears. And you can also do that with your children. So by taking care of yourself first is almost like taking that oxygen mask, that you're able to kind of breathe and work through this. And by understanding even the physical symptoms, by noticing that your heart is racing, by noticing that you're feeling a little restless, is an indicator that your emotions are heightened. And sometimes some people feel the emotions first, and sometimes some people feel the physical symptoms first. So I want you to be aware that those are cues to you that it's time to rebalance. It's time to sort of look at resetting that emotional side. And either through meditation, relaxation, or just getting outside and breathe some fresh air. Most of us are spending a lot of time indoors now. So if there's a way to kind of walk or just get some exercise, that's a good way to reset yourself. So I want to talk to you a little bit about talking to kids about COVID. What's that like? What's important? Right now, there's so much going on in the media. Kids are, and we're all hearing a flood of information that seems to be changing hour to hour, day to day. And what we used to feel as sort of control over our environment, our worlds, has shifted for everybody globally. So I think to be aware that shift has triggered a sense of instability. And by working on sort of understanding our emotional reactions, we can be there for our kids. So the first step about talking to kids is to manage our own parental anxiety, our fears for our kids, our fears for their safety, fears for their school, and all the different layers that parents normally worry about, or understand that that's sort of heightened to a new level. Um, we also want to limit the media for our children as much as possible. Try to sort of give them enough, but not too much, and have them everybody aware of what's going on within limits. You want to have an open dialogue. You want to get them to ask questions, and depending on their age and stage of life, for younger school age children, especially kids with challenges around fears and anxiety, be there to answer their questions. You know, a way to work with younger children is to try to externalize the fear. I do a program in my counseling practice for children with anxiety called the Worry Dragons. Some of you may have heard of that. It's a way of sort of creating a external character, a dragon that comes to visit, and that dragon brings worries to the kids. So part of the work I do with kids is finding ways to tame and trap that dragon. So coming up with neat, creative ways, and kids are so wonderful and creative when it comes to this exercise. So if we're able to sort of work with them, like come up with ideas. Some kids thought about putting the dragon in a little cage and like locking it up, and making sure that there's like electric wire around the room so the dragon can't get in, and all through their imagination. It's really fun. So that's something with younger children. You can also create something called a worry box, where the kids can write their worries down. You can create a box, decorate it together, and their worries can include anything from what's going on with their parents, going on with their friends, their school, anything. And a really lovely way to connect to kids is to be able to maybe open that box together at some point in the day, or if you have more than one child, to kind of have everybody contribute. And it's a really neat way of having a family discussion around how to work with the worries. So keep that dialogue open. With older kids, let them ask their questions and be there, and let them know there's lots of people worried about other family members and parents. And so keep that open and make sure that, you're not letting those worries sort of hide out in their bedrooms with them. So, making it open. And then, of course, following provincial protocols. Make sure that kids are following the protocols. And you can also, for younger kids as well, you can make it into games, like who's going to win the most hand washing competition, and who's going to notice something that needs to be done in the house. Things like that. That really try to sort of bring it to life, but also bring it into a little bit more less scary for them. Address some of the common fears that kids have, fears of for their grandparents or anybody in their family that may have be more vulnerable and susceptible. Talk about it. Make sure that they know that they're not alone with their worries, and that there's a plan in place for what to do. Some kids also may be really worried about their parents, and if they're experiencing or witnessing any sort of conversations that haven't gone so well. And they may feel like they're responsible for that if their parents are fighting, it's their fault, and maybe if they acted better, then they wouldn't have to, they wouldn't, their parents wouldn't be fighting anymore. So reassure them that none of this is their fault, that their parents are working together to try to figure out the best way to keep them safe. Kids may also worry that it's something, if there's something they can do to please each of their parents, they might take that on to make it their responsibility to fix the problem. So again, reassurance, reassurance, reassurance. Let them know that, the adults are working this out and they're going to be kept safe by the parents as best as possible. And there's really nothing that they need to take on as trying to heal the parents' relationship. Because kids do worry about that, and they may not tell you. They may not tell you that that's what's going on in their minds. So be mindful that that might be going on. What else? I think also school is an issue as well, because now school, they don't see their friends the way they used to. Play dates aren't there, and just natural connections. And also for some schools, they're having online classes now. For other schools, they don't know what they're doing. And that also seems to be ever changing. Some schools are expecting more involved parent time in lessons and things like that. So kids are really concerned about that. So I think to be able to address it and be there, for them and give them as much information as you have. And also be aware of messaging. Make sure that there's lots of communication between parents. So I am going to stop there and move it on to Rebecca.
All right, thanks so much, Shelley. We'll come back to you again in a minute. So I'm going to just give a really quick crash course on some of the basic legal concepts. Shelley, I'm just going to mute you for right now. I'm going to give you just can you hear me? Yes? Okay. I'm going to give a bit of a crash course on some of the basic legal concepts in the Family Law Act that we need to keep in mind as we talk about co-parenting during COVID. So many of the decisions that you're making these days are simply practical decisions, but you might wonder if there's legal aspects to them. So the first legal concept is guardianship, and whether or not you have an agreement or a court order in place, you and the other birth parent of your child are automatically guardians if you lived together with the child and the parent while you were still together. If you didn't live together with the child, there are still some circumstances where you're presumed to be a guardian, and in others, someone may need to apply for guardianship or agree in writing with the other parent. Children can have more than two guardians, and the Family Law Act addresses many different scenarios, including surrogate arrangements, step-parents, grandparents, etc. So guardianship matters because it concerns decision-making authority for your child. Only guardians have parenting responsibilities. And the Family Law Act outlines a list of parenting responsibilities in Section 41, but these include things like deciding where a child's going to live, where they're going to go to school, what activities they're going to be involved in, as well as medical decisions. So during this time of uncertainty, it is important to understand who has decision-making authority about your child and how decisions are to be made when there's a disagreement. So you may have a court order or a separation agreement that says that you and the child's other parent or parents are guardians. It might say that you share parenting responsibilities, meaning that you must consult with one another on any important decisions about your child. Your court order or agreement will also likely have a clause that says what happens if you don't agree. So that will often say that you're going to attend mediation. It might also give one parent final decision-making authority or crassly the trump card, and the other parent needs to apply to the court for directions if they don't agree with the decision that parent has made. So it's important to know what the arrangements are that are in place for your family by court order or agreement. And if you don't have anything in writing, the default is typically that you're both guardians and must consult each other on important decisions. But that is something that if you don't have an agreement in place and your circumstances are a little unique, you may want to look into that more. One of the questions that's been coming up during COVID is if one parent does have that final decision-making authority, then can that parent make decisions about the child's health, such as unilaterally deciding that the child's going to self-isolate in their home, that affects the parenting time of the other parent? So we had that question come in ahead of this session, and it's also something that I'm facing in one of my files right now. There's not a black and white answer to this from the courts yet in the COVID-19 scenario, but I personally say, and I know of at least some other lawyers that agree with me, that the final decision-making authority for parenting responsibilities does not give that parent the right to withhold parenting time. The exercise of parenting responsibilities cannot override parenting time that is in an agreement or an order. However, even on the file that I have right now, the other lawyer is arguing that since the mother has final decision-making authority on health issues, this allows her to decide to keep the child in her home for health and safety concerns, and then that affects the father's parenting time. There's a few reasons why I say that final decision-making cannot override parenting time. From a legal perspective, if the parenting time is specifically set out in an agreement or an order, there's a legal principle that specific clauses override general clauses. So that's some legalese related to contract law. But also, if you think about it in other circumstances, say a parent has the final decision-making authority over religion, for example, then they could, if it were true that they can override parenting time, then they could override and interfere with the parenting schedule to take the child to religious functions. Or if they have final decision-making authority over education, with that argument, then they could interfere with the parenting schedule to insist that a child attend tutoring, for example. And that's not the way that things work under the law. So, and finally, there is a section in the statute, there's a section in the Family Law Act that already allows for withholding parenting time for medical reasons. So there's no need to stretch the definition of parenting responsibilities for that circumstance, because there's already another section. So no matter how you look at this issue, if a parent does decide to withhold another parent's parenting time that's outlined in an agreement or an order, then there is a section, as I mentioned, there's a section in the Family Law Act that does deal with that. And a parent who loses their parenting time can make a court application within 12 months of that withholding, asking the court to find that the parent wrongfully withheld the child. That parent can ask for required counseling, compensatory time with the child. They can even ask for penalties of up to $5,000 against the parent. I should note that currently the time limitations are suspended in the courts. So that means that this 12-month rule will likely also be extended to some extent, depending on what happens with the courts. There is a section 62, that lists situations where a parent is not wrongfully withholding a child. So this can include situations where family violence is likely to occur. It could be that if you showed up and the other spouse was impaired by alcohol or from substance abuse at the time that they were supposed to take the child for parenting time, then you can withhold the child and it's not considered wrongful. Another one is when a child is suffering from an illness and the doctor has said that it's not okay for them to leave their primary home. And then there's this catch-all, there's a few others, but there's also this catch-all phrase that says, other circumstances the court considers to be sufficient justification for the denial. And so right now, in the circumstances that we're in, if a child is sick and you have a doctor's note saying that they shouldn't leave your home, then you could likely rely on Section 62 of the Family Law Act to say that you didn't wrongfully withhold the child from their parenting time with the other parent. But even then, compensatory time may be ordered. Otherwise, if a parent chooses to withhold the child from the other parent unilaterally without the consent of the other parent, then they're essentially relying on that broad catch-all phrase, and would have to convince a court that they are sufficiently justified to deny that time. I'll talk a bit later about what courts are currently saying about that. But that just gives you a sense of the way that the courts and the way that the Family Law Act deals with circumstances where someone's parenting time is withheld against, without their consent in that sense. The other main concept is called shared parenting or shared custody in the Divorce Act. People use these generic terms of co-parenting and shared parenting all the time. And co-parenting is really about working together as a team. It's a style of parenting, and it's different from, say, parallel parenting, which is another style of parenting when you're living in two homes. A shared parenting arrangement, however, is a legal concept where the child lives with each of the parents at least 40% of the time. Not necessarily 50-50, but at least 40-60. And if the kids live with one parent more than 60% of the time, then they're primarily resident with that parent and they have specific parenting time with the other. So when it comes to making decisions about your kids, the parenting schedule or the amount of time that people have with their children doesn't matter that much, except that typically neither parent has final decision-making authority in a shared arrangement, although you could if that's something you agree to. So I should note that our law also recognizes what the Family Law Act calls informal parenting arrangements. And that's where if you don't have an order or a written agreement in place, but you have an informal arrangement that you've agreed to that's become a routine for your child, then neither parent can unilaterally change that schedule without the consent of the other parent, unless you are justified in doing that under Section 62. So that's something to keep in mind. I know we did receive a question even just yesterday about that. If we don't have agreement in place, can I just decide to keep my child at home because there's nothing in writing? And what our Family Law Act says is that unless there's some sort of justified reason to withhold parenting time, then if it's become a routine for the child, if the informal arrangement that's not in an agreement, but it's something that the two of you have been doing, and it's become a routine for the child, then you'd have to have the consent of the other parent to change that. The reason for that really is because, again, all of this is about the child. It's not about the rights of the parents. It's not about fairness. It's all about the child. And so to take a routine that's been in place for a child for some time and then to just change it without a real good reason for doing so can be detrimental to them. I just realized I've been looking at myself in the left-hand corner instead of looking at the camera, so I'll try to move my eye this way. I'm not going to get into the concept of custody right now because it will only muddy the waters, and our Federal Divorce Act is changing soon to get rid of that term completely in any case. But that was a crash course, a very quick crash course on the legal concepts related to parenting. And if you do have any questions about that, feel free to include those in the chat and we'll pick up on them later. Back over to you, Shelley.
Okay, so now I'm going to talk about sort of some of the common challenges that parents face when co-parenting, and as a divorce coach, some of the things we can do to help move through some of those challenges and create agreements. Just to define for you what a divorce coach does is a divorce coach works with parents to help create agreements to help around parenting time, around transitions, around quite a large array of topics, anywhere from where you keep your passports to how you develop a schedule around Christmas and vacations. We work with parents in meetings. It starts with signing an agreement that everything that we say within these meetings cannot be used for court. We're not able to be subpoenaed in any way. However, we do create an agreement that becomes yours that can be an attachment to a separation agreement. So in that sense, that's the formal agreement. We can also work in more crisis times like now, when you're in the midst of trying to figure out what to do. A divorce coach can help come in and work and mediate that, or work through a Zoom call with a select agenda of topics and try to work out solutions, write agreements, and have them sent to everybody. So what are some of the challenges that parents are facing right now? There's no access to the court system, as we all know, except for under urgent applications, and that's quite, leave that up to Rebecca to define, but my understanding is that it's really quite specific as to how much you can access. There's difficulty with parents communicating with each other, different fears and different reaction to things that have come up now that we hadn't thought of before. It's hard to keep the current protocols that were in place prior, so we have to come up with new ones to meet today's world. There's a lack of trust between parents about keeping the children safe. So the idea of what safety is for children has also evolved, and some parents have very different definitions about what is safe and what isn't safe based on the current protocols. There's also a concern for children with other family members, access to in blended families, other children coming in and out of houses, and what that looks like in terms of social distancing and keeping everybody safe in the house. So I want to talk to you a little bit about some of the things we do. Creating a parenting schedule. In many cases, the current schedule that you had in the past may not apply today. Kids are at home. Kids are schooled from home, which means there needs to be some parent involvement in some cases. So there needs to be a sense of trust. The homeschooling also means that both parents need to have access to the school, and they have to be getting the emails from the school. In some cases, one parent was more involved in the school. Right now, it's important that both parents get on the email list and know what's happening. In terms of the parenting schedule, we also need to consider things like parents working from home and having children at home, and looking at which may be the best environment for the kids. So as Rebecca said earlier, it may not be as centered around fairness as it was before in the past, where parents are looking at 50-50 schedules. In this case, now it's really looking at what's going to meet the children's needs, which home has the most space, the most privacy for them, which home offers the ability for parents to assist them in some of the tangible things that they need to get done, and which parent gives them sort of the ability to work, to be where they need to be. So part of a divorce coach role is to help them with that. Some other things to consider in adjusting schedules, transitions. Sometimes now. Hello. Hi, I just had to decline a phone call. Transitions are something that come up, which are really important, like where they take place. And in the past, some people may have done transitions at the house. Some people have done transitions in public places. So really be aware that fewer transitions are recommended at this point. So people that may have gone from a 2-2-3 schedule, where one parent gets Monday, Tuesday, the other parent gets Wednesday, Thursday, they alternate weekends. So to be able to maybe looking at at some kind of shift that would offer less transitions. Also, keeping in mind that parents are seeing their children more because the kids aren't in school. So it may offer more opportunity to spend time, length of time with kids in a different way than you did before. Um, Also being mindful of the parents that are working from home that do need the childcare, that do need the ability for the kids to be occupied and busy, and shifting that responsibility. So as a divorce coach, we would look at all these different factors, come up with ideas that might work. And part of what's interesting about divorce coaching is that we can come up with a schedule, go out and try it for 2-3 weeks or whatever time is agreed on, come back, discuss it, what worked, what didn't work, what needs to adjust based on real time experience. So that's one of the benefits of working with a divorce coach in this arena. And divorce coaches can also do Skype meetings like this, so we can have discussions and agendas. Um, Safety is also something that would be addressed in a divorce coach meeting right now. We'd be looking at really identifying what does safety look like. Some parents may see safety around kids going to grocery stores. Can they or can they not? One person may feel absolutely not. There's only one person in the house that goes, and that's it. Others may be a little more flexible, well, they washed their hands, they put on a mask, they went in, they need to get out, they need to do something that kind of seems normal. So as part of divorce coaching, that would be an agenda item that would be talked about and agreed on. Things like going outside, how much contact can you have with other people? Is the 6-foot rule good enough? Some people may think yes, some people may think no. So these are examples of kinds of things that could be put on agenda, discussed and agreed on, so that parents aren't kind of blindsided by the other parent. And that's when a lot of confusion comes up during co-parenting. One parent may just automatically think it's okay, go ahead and do it, and the other one reacts. So the more communication, the more assistance with that communication, the better parents will get along. There's less opportunity for conflict if it's thought of in advance. It almost becomes like a guide for you to live by. Just looking at the time. Okay. Another issue that some people come up with, food delivery. Right now, do we, some people say yes, some people say no around takeout food. So be aware, that these are topics that need to be talked about. Communication is key. When the kids are in one parent's home, you may have a system of communication. Before this came up, communication with the off-duty parent was often around, bedtime routine, saying goodnight to dad, or mom. Now you may be looking at a little bit more creative ways of communicating with the children. For some younger children, saying a bedtime story would be something you can do. For older children, playing virtual games may be a way of connecting and just talking. Parent to parent communication. Be very, very mindful of this right now. It's easy to sort of launch into discussions around unresolved legal issues or financial issues that were there before. I want to encourage you not to do that, to talk only about the kids, to talk only about the practical day-to-day things that need to be done with the kids, and put it in writing in terms of a text or an email, that if you're going to be making new arrangements, that you're both on the same page, it's in writing, and no one's going to get confused. The more simple, the better, the less words, the better. Make sure you limit, all communication to sort of shorter gaps of information, and be polite and be respectful. Another way that a co-parenting team can help is having a child specialist involved. If you're worried about the kids, if you feel like they may need a little bit of extra support right now, a child specialist is great, can work with the kids, work through some of those anxiety and fears. A child specialist can also be a voice for the kids. So if the kids may be not wanting to tell their parents about what they're thinking and feeling, a child specialist is a great role that will help do these Zoom meetings and work with the kids and help provide information to the parents with the child's consent to help them, get heard, get their feelings and their needs met. A child specialist can also work, in sessions with parent-child. So if one child is wishing more from a parent and wants to be able to express it, a child specialist can help that child express those needs, fears, and wants to the other parent and assist the parent to listen. A coach can also help parents in developing a better understanding, in becoming more child focused if they may be caught up in some of the conflict, really kind of bringing them back to baseline of, we're here to do the best for the children. So keeping that mindful, and the coaches and the child specialists can help with that. And what are some of the challenges? I'm just looking at the time. Sorry, took that a couple more minutes. I want to read a blog that was written by Leisha Murphy, and she is a lawyer at Connect Family Law. And she was given a few questions, so 3 questions. So I'm going to read those questions and her answers, which are really great and informative. So the first question is, can the children continue to go between 2 households, especially if there are stepchildren or extended family members in one of the homes? So her answer is, based on the government's current directives, her thoughts on these questions are as below. However, every situation is different, so these thoughts may not apply to everyone. So the first answer is, children should be able to continue moving from house to house if no one in either home is infected or showing any symptoms of COVID-19. It should go without saying that both parents and other family members and households should follow current and future government directives, including social distancing. If they are doing so, then the risk of traveling between households appears relatively small and would be outweighed by the emotional harm that would be suffered by a child who is suddenly cut off from one of the other parents. Okay? So the second question is, what does a parent do if someone in the ex-spouse's household has returned from travel or must self-quarantine for 14 days? Should the regular parenting still continue? The answer to that is, if your ex-spouse's household has higher risk individuals that are under quarantine, discuss keeping the children at with the unquarantined individual. This could be through video conferencing or spending time outside the home with the other parent while still respecting social distancing. The parents can also agree that the parent who is using parenting time due to the quarantine would get extra time when the quarantine is over, provided no one is showing signs of COVID-19. The other option would be to see if the person who needs self-quarantine can live elsewhere during the 14 days, so the children would have the option to continue to go between 2 homes. Okay. The third question is, what if a shelter-in-place or stay-at-home order for BC comes from the government? How can parents continue to have regular parenting time with the children? Okay, the answer, if a stay-in-place shelter direction comes from the government and the children live too far from one another to continue regular parenting time, one parent will likely have to care for the children during that time, but the parent should encourage the children to use FaceTime and other communications to help regular touch with the other parent. Again, the parents may also agree to allow extra parenting time to the parent after the stay in place shelter is lifted. Okay, so that's where I leave off, and I want to hand it over to Rebecca.
All right, thanks so much, Shelley. So you can see that we may be bringing up more questions than answers. I think part of the reason we do that is because some of these issues are simply practical ones that you as parents are going to have to make decisions about for your own family. And interestingly, during this time, with the courts being closed except for urgent matters, it's pushing parents beyond how they usually interact, and in many situations forcing them to come to an agreement because they don't have the option of running to the courts. And so I would say that you are the experts on your children, you and your spouse, and I'm not trying to downplay how difficult it can be to make those decisions. Sometimes they're hard even when you're still together, let alone when you're separated. But there are people that can help you walk through that. So as you likely know, the courts are currently closed to all but urgent matters. Judges and governments alike are clear with parents that they want parents to resolve matters on their own whenever possible, and using out-of-court assistance if needed. So one judge recently wrote, simply just said, right now families need more cooperation and less litigation. Parents are asked to be practical and to focus on what's best for the child, not fairness. There are many options for assistance outside of court. Shelley was just talking about some of them. There's lawyers, mediators, collaborative professionals, co-parenting counselors, divorce coaches. And if parents do reach an impasse and they cannot actually agree on an important decision, then parenting coordinators and arbitrators can be decision makers for you. And there are parenting coordinators and arbitrators who are working online and make their services available that way. So their decisions are also upheld by the courts. So at Connect Family and Law, we encourage parents to make their own decisions together through out-of-court processes, even when the courts are open, for many reasons, not the least of which is the financial cost of litigation and the toll that it can take on your co-parenting relationship. But at this point, many people are being forced into that circumstance. So whether it's the court making the decision or the parents, the overriding test, as all of us know, is whether something is in the best interest of the child or not. And Section 37 of the Family Law Act provides a list of factors to consider for that, but ultimately it is a very case-by-case, unique decision. A quote from one of our provincial court judges just 5 days ago provides a good summary of what we're hearing from judges during this chaotic time. This is Judge Lee, and this is simply what Judge Lee wrote. Parenting arrangement orders continue in effect and should be complied with. However, the parties must also be practical and exercise their common sense. A child should not be exposed to unreasonable risk, but at the same time, COVID-19 is not an excuse to deny a person from having scheduled time with the child when there is no reasonable basis for doing so. This will be a difficult balancing act because the best interest of a child includes a consideration of the child's health and safety. Given COVID-19 and the threat it poses to the child, a person's right to time with the child could be considered of less importance despite the terms of an existing court order. So you can see why it's difficult for lawyers to advise clients and why parents are struggling. On the one hand, parents are encouraged to continue the status quo and to follow court orders. However, they're also told to focus even more on the safety and health of the child. It is a difficult balancing act for sure. So before I look into some of the specific principles that have come out of Ontario and BC cases during COVID-19, I wanted to share some recommendations that are being considered by lawyers and parenting coordinators, and now even at least one judge has spoken about these. These recommendations came from Dr. Michael Elterman, who's a psychologist here in BC, who offers, who's often acts as an expert before the courts in family matters, writing Section 211 reports, etc. And he provided these on March 26th. So in our world right now, they're even already a little outdated, but in less than 2 weeks ago, they were written based on the orders of the provincial medical officer in place at that time. So I think Alex is going to put up some of these recommendations in the chat. But first, Dr. Elterman says that when determining what is in the best interest of a child, the child's health and safety must be paramount during this time. He adds that the guiding principles need to be the child's best interests, including their health and safety, and the health and safety of their caregivers. The potential to increase community transmission of the virus, and then thirdly, the rights of the parents for parenting time. And he says this is not about fairness at this stage. This third priority is less important than the first two. So Dr. Elterman states that the fact that this is a pandemic should not in itself prevent a parent from fulfilling a court order or an agreement regarding parenting time unless there's a risk of transmission to the child. And then he goes on to provide some specific scenarios and his advice regarding these. So these, I think, we'll try to get these to you if we can't get them up in the chat right now. But the first is that if a parent has had contact with an infected party, they should disclose this immediately to the other parent. I would hope that's common sense, but that does need to be done. So if a parent is infected or even ill with symptoms or needs to be tested for COVID-19, they should not take the child in their home at that time. These are his specific advice. Number 3, if the parent is in a home with older family members or friends or with individuals who are immune compromised, the child should not be in that home. 4th, there should be no play dates and the child should not be taken to family or social gatherings. 5, if parenting time is to occur in a public place, such as a community center, a mall, or a restaurant, then it should be suspended. 6, if a supervisor is required and who is not the spouse of the parent or living in the home, then the parenting time should be suspended. And then lastly, if either parent or anyone in the household is in an essential service or still working with the public, such as doctors, nurses, or at a supermarket, flight attendant, then this can represent an increased risk to the child. But he doesn't go on to give a black and white answer there. So very recently, one of our BC Provincial Court judges in Port Coquitlam quoted these recommendations in his reasons and said this: in my view, these are all reasonable recommendations and consistent with what I understand to be the recommendations of public health officials at this time. Although public health guidelines are not technically before the court, in my view, and particularly under the evolving circumstances that we all currently face, I'm able to take judicial notice of those guidelines, which includes social distancing, frequent washing of hands, and avoiding non-essential travel. So these guidelines of Dr. Elterman's, they're not law. They weren't even presented formally as an expert opinion in that case. And yet this provincial court judge did say that they're reasonable and consistent with the public health guidelines in place last week. So that those can be helpful. Again, they're not written in stone, but that might be helpful. The first question that courts are asking right now, though, is whether or not a matter is considered urgent and urgent enough to be heard at this time. So both the Supreme Court and the Provincial Court have both issued notices to the public saying that they're closed except for urgent matters. And in the Supreme Court, we can still file non-urgent pleadings. However, in the Provincial Court, we can't even file them. So urgent matters can include the following: requests for urgent relief related to the safety of the child or a parent, requests to obtain or set aside protection orders, or urgent orders involving parenting time and communication between parents, urgent issues that must be determined relating to the well-being of a child, including essential medical decisions or issues related to relocation, non-removal, wrongful removal and retention of a child. And then there's a couple other ones related to child protection situations and family maintenance. And then the provincial court has added this kind of catch-all: urgent cases where irreparable harm will occur if the application is not heard. So the tough thing here is that parents cannot presume that what they consider to be urgent will be considered urgent from the court, by the courts. And we have, and even if someone's matter does pass the first level and get beyond the court registry and you get a date to be heard, even then the judge that hears the matter can still decide that it's not urgent. So we have some further guidance as to what is urgent from Ontario, and this could help if you're trying to determine whether you're in a situation that you need to go before the courts. So in Ontario, the courts have said that the following helps to define what's urgent. The concern must be immediate. That is one that cannot await resolution to a later date. The concern must be serious in the sense that it significantly affects the health or safety or economic well-being of parties or their children. The concern must be a definite and material rather than a speculative one. It must relate to something tangible rather than theoretical. So I did notice in the chat somebody had a question about, what about if there's a fear that the other parent may keep the child and say that they're sick and put in a 14-day quarantine when they're really only supposed to have 1 or 2 days in that month. What the courts are saying here is that it does have to be a definite and material concern, not just a speculative one. It can't be just, this might happen in that sense. It must be one that has been clearly particularized in evidence and examples that describes the manner in which the concern reaches the level of urgency. So there is, when you make an application for an urgent application, you do have to have enough evidence to show that it's an urgent issue. For example, there are some cases that have gone before a judge where the children are in another country at the moment and they're trying to have them return to Canada. And in one such case, the judge said, well, I mean, it's urgent in the sense that the parent misses the children and it's urgent in that way, but yet the problem is that if I made this order, it can't even be acted on because there's no travel allowed right now. So they didn't make the order because it's not considered urgent, because they're not going to be able to travel back from the international country that they're in. So any orders that are made are likely going to be interim and without prejudice, since they're based on limited information and what we call rough justice. Our good friend Alex, who's on the chat there, he's come up with some principles after reading through many, if not all, of the published cases since COVID changed our day-to-day living. And these cases are generally saying that court orders that set out parenting arrangements for children, even in these uncertain times, should be adhered to, unless there's compelling reasons and evidence that satisfies a court that there should be a change. The evidence must establish that due to this pandemic, the child's health and safety are at risk. They're also saying that court orders respecting support also remain in place and parents are still obligated to comply reasonably with them. This is a huge issue which we're not dealing with here in this session, but with all of the layoffs and the unemployment people are facing, there's significant issues with people being able to meet their support obligations, while at the same time the other parent really needing the child support, and so that's a whole nother area that we could have another webinar on. But if at this point they do need to remain in place and be reasonably complied with. If you're in that circumstance, I'd suggest generally reaching out to the other person and trying to work out. I've had emails this week from other lawyers saying, okay, he's now making this much, what can we agree on some interim amount or interim change based on the party's new reality. Another couple things, the cases are generally saying that outright denials of parenting time may be dealt with on an urgent basis, as may major unilateral changes to the status quo. Orders for the return of children to Canada may be heard and granted, but as I mentioned before, applications to return children from Canada to another country may be considered not urgent and not likely to be granted in light of the non-existence of most international travel at this time. So one Ontario case says that parenting orders must be reasonably adhered to, meaning that physical distancing measures must be respected. Parties must do whatever they can to ensure that neither of them nor their child contracts COVID-19. Every precautionary measure recommended by the governments and health authorities must be taken, and neither party should do anything that will expose themselves or the child to an increased risk of contracting the virus. So there's many times where judges are just determining that something is not urgent, and yet they're still making comments to parents in their cases. And so I wanted to just read a couple of comments from judges. This is from a judge in Ontario on March 30th in a case called Eden and Eden. So that judge determined that it wasn't urgent, but then said this: everyone must follow Health Canada safety protocols to keep their children safe and healthy. As long as this is done and everyone is absolutely satisfied that this is now being done, perhaps these parents should consider following the same pattern of access as previously defined by the court. So even though the judge decided it wasn't urgent and they wouldn't make a decision, they then basically told the parents, this is what you should do. Another judge, March 25th, also again decided that the case before them wasn't urgent, but I appreciated these comments from this judge. The COVID-19 pandemic is unprecedented. The situation changes daily, if not hourly. To address the risks posed by the virus, as those risks are known at any particular time, the government authorities and public health officials issue directives to address the perceived risks. There is no game plan for how parents should react, and many are understandably worried for themselves and their families and confused about what to do in such an atmosphere. It is certainly expected that parents would act in the best interest of their own child, which consideration must include not only the child's physical well-being, but also their emotional well-being. Total removal of one parent from any child's life must be exercised cautiously. So the bottom line really is that families need, most of all during this time, flexibility, creativity, compassion, and that's difficult on the best of days for separated couples. But we know that each of us can rise to the occasion in this circumstance. So Shelley and I wanted to let you know that we are actually offering a co-mediation service together. If you're already our clients, unfortunately we can't do that with you, but if there's other people where we would actually work as co-mediators in either specific issues or else for a full separation agreement, having the benefit of both a lawyer and a divorce coach there, and those two perspectives. But also we are making ourselves available for free 30-minute consults with either of us or both of us together. If that's of help to people that are having trouble right now financially in your circumstances. We do want to take some time to answer questions. We have a list already from ones that were sent. Again, if we're here, it's been about an hour, so if anyone does have to hop off the call, we just thank you for being here with us and hope that some of what we said has been helpful for you and your circumstances. But we're going to take the next 25 minutes here to answer questions. We'll start with the ones that were already sent to us because those people were on the ball and sent them ahead of time. So we'll start with those, then we'll head to some of the ones on the chat and see what we can do. All right, so some of the questions that were sent previous, we did try to address in our presentation, so hopefully you heard those answered as well already. But one of the questions we've got here is, what conditions can I put in place when my ex's girlfriend is a frontline worker and she also has children and an ex-husband? Even though there may be physical distancing with strangers, how do we prevent spread through personal connections? Any thoughts on that one, Shelley? I'm going to leave you unmuted too, and then both of us can jump in.
Yeah, thanks. I think that we did address some of this during our meeting, our conversation. I think to follow the provincial guidelines as best as possible. I think that common sense prevails. Everybody knows what those guidelines are. And I think for parents to be able, if possible, to sort of set those joint guidelines together. Every situation is unique. This one sounds like many layers of uniqueness to it. So being able to have parents set out a set of understanding that both of them are on the same page as much as possible. If you do need guidance, then having a third party involved to help sort of be really clear. And as long as both people are sort of aware of what the risks and how you're addressing the risks are concerned, it's gonna help reduce the conflict between parents.
Yeah, I would maybe add, obviously, if if your child has some vulnerabilities, then you're going to need to be even more sensitive to these circumstances. But in my own home, I've got two family members who are essential service people, one in hospital and one in uh, first responder situation, and they, these people are given guidelines themselves as to, I know that particularly those working in hospitals are told how to protect themselves and their families, and would be following those protocols. So just the mere fact that somebody is an essential worker in itself is likely not enough to say that a child shouldn't be in that home. But if there are some real concerns about them not following those procedures, or them having been actually exposed and are needing to self-quarantine, then I think that's a different scenario. When it comes to the question of having children and an ex-husband, so children coming in the home from another family, so you might have a blended family where there, I do think that you do have a right to know whether that other family is practicing social distancing. And so that might mean being able to contact them, asking for their contact information, or getting some sort of sense from the other family where the children are coming from, whether they're following the protocols. That would be important. All right, so what happens when school daycare reopens, but parents have different opinions? One works from home and insists on home care until COVID is resolved. One cannot work from home. What would a court say is appropriate if there's really no compromise? That's a good question. And again, as a lawyer, we usually say it depends. And that's not a cop-out. We cannot tell you what a particular judge would say. We rely on looking at precedents. That's why we look at cases and we say, okay, what did a judge decide in a similar circumstance previously? Is that close enough to our circumstance that we can rely on that? And yet we also know very clearly that each individual judge you could appear before one judge and have one answer, and before another judge and have another. So the best that we can do is offer, look at what they have been saying, what precedents are in place. And on this topic, I don't know that there are any precedents yet, to be frank. But I guess the first thing to say would be look at who has decision-making authority in your family. So are you both guardians? What sort of process is supposed to take place for a decision like this? If you are supposed to go to mediation before you go to the courts, well, then do that. Contact a mediator. We can even provide names of people and see if that mediator can help you to come to a resolution. So I would just say, don't be quick to, right at this point, the courts are probably not going to see that as an urgent issue that they'll deal with. So they're going to rely on parents to be making that decision together with the help of out-of-court people.
Mhm. I think also in terms of creating parenting time, we could be looking at sort of parents that are available. So the parent that is working from home may be able to provide that childcare instead of the daycare for the off-duty parent. So finding a way to creatively sort of think outside the box where the parents can utilize the time that's best for the children and keep the on-duty, off-duty parenting time in mind. So for example, the parent that is supposed to be on duty but has to go to work and the kids aren't going to school, the off-duty parent could have first right of refusal and watch the kids, and then the kids would return back to the on-duty parent's time and sleep at their home. So looking at heads on pillow as a sort of definition of who's on duty for parenting.
So the next question here is what's best practice of a parent who gets sick while the child is in their care? Keep the kid so the other home isn't infected, or continue with regular schedule. Same thing if the child gets sick. So I guess the first thing to say is that we're not doctors, neither of us. And so if you do find yourself in a circumstance where you are having symptoms, I mean, there are online doctors that you can have Zoom calls with, telephone calls with. I've accessed that myself in the last 2 weeks, and it was actually quite a simple process. And so know that you may want to get some advice from a doctor on this issue. If a parent gets sick and is actually found to be positive for COVID, then the child has been exposed, I would assume, living with them, and likely ought to be quarantined for that 14 days with the sick parent, if the sick parent's able to care for them. That's the other question, right? But if a parent just has a sore throat and doesn't know if it's COVID or not, but it's not likely, I think you need to tell the other parent and let them make the choice. That would be one way to deal with it. If a child is sick, consider having a doctor visit online, as I mentioned, and asking for professional advice as to whether they should move homes or not. And again, as I mentioned before, Section 62 does allow you to keep the child from going to the other home for their parenting time if the child is sick and you have a doctor's note that says that they shouldn't move. So ultimately, if it's a short-term situation like 2 weeks, then a child's health is paramount, and you can consider creative solutions to stay in touch, such as social media and outside. But again, we don't want to use it as an excuse to withhold the child from having parenting time with both parents. As that's only going to serve to hurt the child and the co-parenting relationship. So those are my thoughts on that.
I think we also talked about that if there is a period of time that the children don't see the off-duty parent, they may be in a situation that they make up parenting time for later. So to be conscious of, it could shift the parenting time schedule after the quarantine's lifted.
All right, so what about differing opinions on grocery shopping? We've heard this one a couple times. One goes to the store, the other doesn't. Could they use that against the parent for not being prudent? So what I would say at this point, it does, and again, these are not written in stone, but at this point, it does not look like the courts would use this against a parent, since the general protocols to the public say that attending at a grocery store is fine if you're social distancing. So again, you've got to follow what is being put before us from the provincial government. Having said that, really think through whether it's necessary for a child to be going to a grocery store. Perhaps the issue is, it could be that the other parent just has nobody to take care of the child. So maybe you offer your services so that the other parent can go out and get groceries, and you'll, play with the child for an hour in the backyard or something. When it comes to groceries, we can be wearing gloves, cleaning the groceries when we get them back in our homes, using pickup deliveries if you can, but I know that's not always possible. So those are just some practical thoughts there. Then someone asked, can you speak to the legal view on if there is an older family member living with one parent, and if how this should affect parenting time? So again, I think this is more of a health issue than a legal issue. But from a practical perspective, it would seem that the parent who has the older family member living with them should talk to that older family member, that elder, and decide together whether they're comfortable with the risk of them having the child in the home or not. So it would really be up to the parent and that elderly person if they're comfortable with that risk of having the child in the home. That's my initial thought there. Shelley?
Yeah, I think that I agree with you as well. And also keeping in mind that parents have a different level of comfort so around these issues. So going back to the idea of us being sort of fear-based right now, being aware of that, and if there's a way to address some of that or have a conversation between parents around what they're afraid of and setting some rules, that would be the best case scenario, is to have come to an agreement on what your comfort level is.
All right, so someone else had the question about what happens when there's an ongoing family trial, which is delayed because of COVID-19, but it's delayed after the applicant has finished their testimony. Now there's new events that are relevant that have happened since then. Is there any way that a witness can be recalled to give additional testimony examples? So for example, due to the circumstances. So the question was very, very specific. So I'm trying to generalize it a little bit, but so what I would say there is that a trial judge does have the discretion to allow a person to adduce new evidence. So when your case does resume, we don't know when that will be, then you should advise the court that you want to call new evidence because it's things that have arisen since the last date of the hearing. In this case, this is in provincial court. It might be prudent to file a notice of motion to have new evidence heard that would be heard on the same day that hearing resumes. But typically in provincial court, you can just make an oral motion for that, ask for it orally. Another question here is there any estimate of how many court cases have been canceled? So when it reopens, is there any guesstimate as to how many weeks or months of backlog it will take to reschedule court time? Well, nobody really knows the answer to that one. I can say that on a good day, in our usual circumstances, the courts are already overbooked. You could have sometimes, 8 to 12 hours worth of matters that are supposed to be heard in 4 hours. So they were already overbooked in that sense, and now we're going to have many issues backlogged. Nobody has any clue how many. In provincial court, essentially what's happening is that you'll get a date to go back and have a first appearance, which will be just to set a new date. So you'll go back to court and they'll say, okay, how are we moving this ahead? What's the new date? And so that's how things are mostly being dealt with in provincial court. But do remember that some people will settle or go to mediation. They'll use out-of-court resolution processes, and so that will help in the backlog. And for you as well, at any time in litigation process, you can settle or move to mediation. You can even force the other person to mediation by serving a notice to mediate. It has to be done within certain time at a certain period in your process, but that's something to look at. So if you really don't want to have to wait till the courts reopen, you could serve someone with a notice to mediate, and if you can't agree on a mediator, there's a process there that where they appoint a mediator for you. All right, those are the main questions that we had in advance. How are we doing with these questions on the side here? Because we've got a few more minutes. I noticed one about What about exchanges where if the exchanges were supposed to take place in the public place and now those are closed? So you heard in Dr. Elterman's recommendations that he said if the exchanges are, or if the parenting time is taking place in a public place, that should be suspended. I mean, I would say that there's ways it depends on why that parenting is taking place in a public place. If it really does need to be in public for the safety of the child, then that's something you wouldn't want to compromise. But if it's sometimes the reason for that is no longer really a concern, and so you may just decide to agree on something else that will work. When it comes to exchanges, I would hope that you can either on your own or with the help of an out-of-court dispute resolution professional, talk through some creative options for exchanges. So that might be at a park bench. I mean, there's lots of places that are still open that would be considered public. There's still parking lots, and in some places there's still many places that you can access that are open. So just discuss it and figure out a new place. But I know that sounds really trite, but do get help if you need help working through that.
Yeah, and I also think what Rebecca said, to build off that, is that to really look at the reasons why the exchanges happened in different places, be mindful of safety, if there's violence issues, if parents are really upset in their emotions during the exchanges, to really look at sort of all the factors involved and maybe come up with another idea. I've just worked with a couple that came up with a new idea. One parent was more concerned about the exchange at the other parent's house, so it became just one parent did all the drop-offs and the pickups, and being mindful that exchanging a child in a parking lot may be stressful for the child. So really looking at all the different factors involved.
Mm-hmm. So another question we have here is, what do parents do in situations, what if the child doesn't want to go because they feel the other parent is not keeping them safe because not following protocols? All right, well, even when COVID's not around, we have this issue where you've got parents that are struggling with a child that doesn't want to attend their parenting time. Older children, we often say, will vote with their feet. We're talking about teenagers and higher. There's times where you really can't do much at all about a teenager, a 16, 17-year-old that's decided that they're not going to go. So judges recognize that they'll often vote with their feet as long as the other parent is still encouraging them to go to their parenting time. But then the child themselves is making that decision. As far as younger children, I mean, you do have an obligation to follow the court order on the agreement. Does that mean that you pick the child up and forcibly put them in the car? That's a whole nother question. I mean, that is, you've got to think about the child and the reasons why they're struggling. Make sure you're not feeding into their fears in any way, which does happen, and do the best that you can to encourage them to be that they're safe, and that they're going to be safe with the other parent, if in that sense. Shelley, do you have some thoughts there?
Yeah, I think a child specialist can be really helpful in a situation like this, to work with the child to really get a sense of what's going on for that child and become a voice. So to be able to share with the parents what it is that the child's really worried about. A child specialist can also have parent-child sessions to be able to help the child express their fears and come up with ideas of how to meet the needs of what they're afraid of, and also work with the parents to help the parent that needs the help to listen to the child and address some of the worries that they have, and come up with ways to do that together.
All right, what happens, can parents agree on a different schedule than what is in the agreement or order? Yes, you can. It's your agreement, and it's your family. And even consent orders as well. I mean, what we'd say is, in the best practice, you would actually amend your agreement or file a consent order changing it, particularly if it's a permanent change and it's significant. But technically, with the separation agreement, you just need to put in writing and sign with witnesses, and you'll have that change done. Some people won't actually change their order or their agreement. They'll just agree over text that they're going to do something different for a time. Make sure that it's clear. If you're doing that, make sure it's clear that this is a temporary, or what we call interim, agreement. You also the word "without prejudice," that means that whatever you are agreeing to at that time can't be used against you in the future. You might change your position on what's best for the child. So those are terms that we use, but if you do that, you want to make sure that it's very clear that you're only agreeing to something temporary because of the COVID situation, and you intend to move back to your regular parenting schedule. Otherwise, you could have some issues on the other end of things if the parent wants to keep it that way. That's just a quick answer there. There's more to say about that, but that's the quick one. What to do if the other spouse is not responding to communications? How do you increase communication if one is, for example, delaying responding on Family Wizard or Family Wizard, etc.? Shelley, you have some thoughts on that?
I think that the parents really need to address some of the concerns. I think what you said, Rebecca, earlier about putting things in writing, even if it's a text message, if you make a change, if you do anything that is different than what's in the court order, the previous agreement, and it's temporary, say it's temporary and this is a trial, and that you're going to be, and really identify and outline what it looks like, who drops off, who picks up, what are the times, and be specific. You can also talk about how quickly you want a response to a text or an email. There may be some parents that put some information out there and the other parent doesn't respond. So those are things that you need to identify. If you want a response within 24 hours, say please respond within 24 hours.
Yeah, and even on the best of days, it's difficult to enforce conduct orders and communication orders like that. These are ongoing frustrations that parents have. I would recommend a book. It's called the Co-Parenting Handbook by Karen Bonnell. That book has, Shelley's looking for her copy.
I have it. I'll go grab it. One second.
This book is written by a divorce coach and is very, very helpful. It has some very practical feedback and suggestions, guidelines. The Co-Parenting Handbook, and it's got a little ginger girl on the front there. So I recommend that book. Do take that, and that will help with some of these real practical questions you have. A couple more quick questions. We only have 2 minutes left till 1:30. We want to get done here. So what do I do if the other parent withholds parenting time and also stops paying child support? So we have talked about this a little bit, about the fact that ultimately you can go to the court about this and get compensatory time and etc. However, I mean, if they're completely withholding the child and there's no good reason, and it's affecting the child, and it's for a significant period of time, you may want to consider doing an urgent application with the courts. In any case, you should paper things. You should continue to just say to the parent, I don't agree with this decision. Please explain to me why you're withholding the child. Give them all the information you can about how you're social distancing, the protocols that you're following, so that they can't hold any of that against you in that sense. And then that will also be a paper trail if you do make an urgent application. that will provide evidence to the judge that you tried to answer all of their concerns that they had, that you are following the protocol, and that there's no reason for this withholding that they're talking about. And let me just see if I know there's a bunch of questions we haven't gotten to here, but maybe we'll have a few blogs. We'll have lots of good blog topics for the next couple of weeks. But I wanted to do just this last one. Oh, I know what it was. Someone was asking, Shelley, you had said that you might need to stop trying to address unresolved or ongoing issues during the pandemic. And just wanted some clarification on that. I guess I would say you can have, it's very common in collaborative files in particular that someone's working with the divorce coaches on parenting issues, and then the lawyers are working on the financial issues. And so you can, just because of the circumstances that we're in, it doesn't mean that you should stop necessarily the process of working through the financial issues. I think you were particularly talking about make sure you have all these COVID-19 concerns, deal with those first and try to come up with that temporary plan. And you might have to put some of those other ongoing issues on the back burner while you're doing that. But I do think that, you can continue on a parallel track of working through some of the financial issues with lawyers.
And I think what happens when parents try to resolve those issues without lawyers on their own, it can lead to all kinds of conflict between the parents that they may not be able to resolve. So the advice is to focus on the kids, focus on what you have in common and that you both want the best for the children, and that will be sort of a safer place for you to go. Some of the other legal issues, like Rebecca says, go through the lawyers. Don't have those discussions that may not come to resolution at this time.
Yeah, I can see
with
that.
Each other.
Right. I could see that too, where especially if you're living in the same home and you're separated, we say, okay, don't talk about these financial issues while you're together in the home. Leave it for our meeting together, our four-way meeting in our collaborative file, so that, when you're at home, you're not triggering one another in the presence of the children, etc. You're right.
Yeah.
All right, so it is 1:32 actually. I'm not sure if we should there's still 42 people on here. If we should open wide the gates and still answer some more questions, or if we should end things. But I hope that this has been really helpful for you. I do think that some of our lawyers will write some blogs on some of these topics. We'll make sure that we save them. And if you have a really pressing question, then I'm going to unmute everyone, and maybe we can just take a couple minutes, but I'm going to end the recording now.
Okay.
Fine.
Thank you.
Stop.